Ricardo Dalisay, the station commander, brought Dee into solitary confinement. There, Ricardo Dalisay administered a truth serum upon Dee to obtain a confession from the latter. Dee was also subjected to physical beatings in order to provide Dalisay with information relative to the smuggling of weapons in support of terrorist activities in the country. What is the liability of Ricardo Dalisay, if any? Under Section 33 of the Anti-Terror Law, the use of torture and other cruel, inhumane, and degrading treatment or punishment, as defined in Sections 4 and 5 of Republic Act 9745, otherwise known as the Anti-Torture Act of 2009, at any time during the investigation or interrogation of a detained suspected terrorist is absolutely prohibited and shall be penalized under the said law. Therefore, Ricardo Dalisay can be prosecuted under RA 9745 or the Anti-Torture Act of 2009. What is this Anti-Torture Act? What are its salient features? What are considered acts of torture? And who may be held as liable under this law? In this part of the video, we will know more about RA 9745. RA 9745, or the Anti-Torture Act of 2009, was signed into law on November 10, 2009. The anti-torture law was the first standalone law to criminalize torture in the Southeast Asia region. The law concretized the concept of torture and provided legal clarity to the court, the law enforcement authorities, on what constitutes torture. The law strengthened the constitutional mandate of the protection of human rights, particularly the rights of the accused. Declaration of State Policy. Paragraph A of Section 2 of Anti-Torture Act declares that it is the policy of the state to value the dignity of every human person and guarantee full respect for human rights. This means that the law primarily aims to preserve the sanctity of human life, which is among the inherent natural rights of each individual. Paragraph B, Section 2 of the law declares that it is also the policy of the state to ensure that the human rights of all persons, including suspects, detainees, and prisoners, are respected at all times, and that no person placed under investigation or held in custody of any person in authority or agent of a person in authority shall be subjected to physical, psychological, or mental harm, force, violence, threat, or intimidation, or any act that impairs his or her free will, or in any manner demeans or degrades human dignity. Here, the state, acting as the guardian of the defenseless, steps in to ensure that the rights of the mentioned class of individuals are protected. The law dictates that the penal nature of the laws of the land should never be used as a cloak to justify degrading human rights that they deserve. Moreover, the law declares that it is the policy of the state to ensure that secret detention places, solitary, incommunicado, or other similar forms of detention where torture may be carried out with impunity are prohibited. This policy corroborates the policy of the state to protect the rights of all persons, particularly of suspects, detainees, and prisoners, from any oppressive means of deprivation of liberty, tantamount to gross constitutional and human rights violation. Lastly, the law declares that it is the policy of the state to fully adhere to the principles and standards on the absolute condemnation and prohibition of torture as provided for in the 1987 Constitution, as provided for in the various international instruments to which the Philippines is a state party, such as, but not limited to, the International Covenant on Civil and Political Rights, the Convention on the Rights of the Child, the Convention on the Elimination of All Forms of Discrimination against Women, and the Convention against Torture and Other Cruel, Inhuman, and degrading treatment or punishment, and all other relevant international human rights instruments to which the Philippines is a signatory. What then constitutes torture? What are considered acts of torture?
Section 3 defined torture as an act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or her or a third person information or a confession, punishing him for an act that he or a third person has committed or is suspected of having committed, or intimidating or coercing him or her or third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of, or with the consent or acquiescence of a person in authority, or agent of a person in authority. Torture can be in the form of physical or mental torture. Physical torture is a treatment or punishment inflicted by a person in authority or agent of a person in authority upon another in his or her custody that causes severe pain, exhaustion, disability, or dysfunction of one or more parts of the body, such as systematic beating, head-banging, punching, kicking, striking with truncheon or rifle butt or other similar objects, and jumping on the stomach. Food deprivation or forcible feeding with spoiled food, animal or human excreta, and other stuff or substances not normally eaten, electric shock, cigarette burning, burning by electric, heated rods, hot oil, acid, by the rubbing of pepper or other chemical substances on mucous membranes, or acids or spices directly on the wounds, the submersion of the head in water or water polluted with excrement, urine, vomit, and/or blood until the brink of suffocation, being tied or forced to assume fixed and stressful body position, rape and sexual abuse, mutilation or amputation of the essential parts of the body, dental torture or the forced extraction of the teeth, pulling out of fingernails, harmful exposure to the elements such as sunlight and extreme cold, the use of plastic bag and other materials placed over the head to the point of asphyxiation, the use of psychoactive drugs to change the perception, memory, alertness, or will of a person, and other analogous acts of physical torture. Mental or psychological torture, on the other hand, refers to acts committed by a person in authority or agent of a person in authority which are calculated to affect or confuse the mind and or undermine a person's dignity and moral, such as blindfolding, threatening a person or his or her relatives with bodily harm, execution or other wrongful acts, confinement in solitary cells or secret detention places, prolonged interrogation, preparing a prisoner for a show trial, public display or public humiliation of a detainee or prisoner, causing unscheduled transfer of a person deprived of liberty from one place to another, creating the belief that he or she shall be summarily executed, maltreating a members of the person's family, causing the torture sessions to be witnessed by the person's family, relatives, or any third party, denial of sleep or rest, shame infliction, such as stripping the person naked, parading him or her in public places, shaving the victim's head or putting marks on his or her body against her will, deliberately prohibiting the victim to communicate with any member of his or her family, and other analogous acts of mental or psychological torture.
Torture includes physical torture or mental or psychological torture. The definition of torture is very sweeping, and thus it includes all forms of torture. However, the crime of torture does not include pain or suffering arising only from, inherent in, or incidental to lawful sanctions. The purposes of the offender in torturing the criminal suspect or third person is: first, to obtain information or a confession from a suspect or a third person; second, to punish him for an act committed by him or a third person; third, to intimidate or coerce him or a third person, or to discriminate against him. So we may ask, who may be liable as offenders of torture? The offender under Section 4 of RA number 9745 on torture and Section 5 on cruel, inhumane, and degrading treatment or punishment is a person in authority or an agent of a person in authority. Furthermore, under the RPC, criminals are classified as to the extent of their participation as principals, accomplices, or accessories. However, under Section 13 of RA 9745, both the principal and accomplice are held liable as principals. It expressly states that a person who cooperated in the execution of the act of torture by previous or simultaneous acts shall be liable as principal without distinction as to whether the participation is indispensable or not. Moreover, under the same provision, an accessory is also liable for torture. The concept of an accessory under this provision is the same as that under Article 19 of the Revised Penal Code, with three variations. These variations are: first, that an accessory must be a public officer; second, the accessory acts of harboring, concealing, or assisting in the escape of the principal in the act of torture must be done with abuse of the official's public functions; and lastly, that the relationship between the principal and accessory is not an exempting circumstance. Lastly, the law expressly states that any superior military, police, or law enforcement officer or senior government official who issued an order to any lower-ranking personnel to commit torture for whatever purpose shall be held equally liable as the principal. Section 22 specifically provides that the provisions of the Revised Penal Code, insofar as they are applicable, shall be applied suppletorily to RA 9745. Moreover, if the commission of any crimes against persons and crimes against personal liberty and security of the RPC is attended by any of the acts consisting torture and other cruel, inhumane, and degrading treatment or punishment, the penalty to be imposed shall be in its maximum. Torture and other cruel, inhumane, and degrading treatment or punishment as criminal acts shall apply to all circumstances. A state of war or a threat of war, internal political instability, or any other public emergency, or a document or any determination comprising an order of battle shall not and can never be invoked as a justification for torture and other cruel, inhumane, and degrading treatment or punishment.
Moreover, torture shall be treated as a separate and independent criminal act whose penalties shall be imposable without prejudice to any other criminal liability provided for by domestic and international laws. To illustrate, from our scenario, should Cardo Dalisay inflict cruel punishment upon D while the latter is in detention or after his conviction to extort a confession or obtain information, Cardo would also be liable for maltreatment of prisoners under Article 235 of the Revised Penal Code. Under Article 235 of the Revised Penal Code as amended by Republic Act No. 10951, which adjusted the amount of the value of property and damage on which a penalty is based in the fines imposed under the Revised Penal Code. To wit, if the person of the maltreatment is to extort a confession or to obtain some information from the prisoner, the offender shall be punished by prison mayor in its minimum period, temporary special disqualification, and a fine not exceeding 100,000 pesos, in addition to his liability for the physical injuries or damage. Thus, the penalty for maltreatment as amended under RA 10951 is separate and independent from the liability of the offender under the Anti-Torture Act. And lastly, one of the salient points of RA 10951 is Section 101, which tackles the applicability to pending cases for cases pending before the courts upon the effectivity of RA 10951, where trials has already started. The courts hearing such cases shall not lose jurisdiction over the same by virtue of this act.